My question today is, we had some work done from a soliciting firm in London. I'm not going to name them. And they done a court case for us. And we had an agreement with them of a capped price because their prices were quite steep. And emails are exchanged back and forth where he's capped the price at an agreed price, what we did, plus VAT. And then after the court case was finished, done and dusted, we received a new bill from him of another 18,000 plus, and including the capped price, which was agreed in the beginning. Are they allowed to do this?
No, with a couple of caveats. So what was the original price you agreed?
It was 8,000 plus VAT.
And they moved it up to 18,000 plus VAT?
Yeah, including, they still want that 8,000 as well.
So they actually want 26,000 plus VAT?
Correct.
OK, have you asked the solicitor for an explanation?
We did. We asked for his complaints department so we was going to lodge a complaint.
Before we get to a formal complaint, what explanation did they give you?
They didn't give an explanation. All he sent was all the notes that they had, which we don't understand because it's not something what we know about. Different time, different notes of what they did in the backgrounds and stuff like that. Made phone calls or speak to this department. That's
not an answer to we fixed the fee at £8,000. You can't charge me 26,000. What did you say to them? We fixed the fee at 8,000. Come on, guys. How are you justifying this greater charge?
We didn't specify exactly how you've said it now, but we did say we're not in agreement. You've broken the contract which we agreed to begin in the beginning.
Is it in writing that their fees are going to be capped at 8,000?
Yes, it's in an email. I double-checked everything. It's all in writing.
Good.
In emails, actually, not physical writing.
That's absolutely fine. Has there been a change of solicitor, of the actual individual handling your case file?
No.
No, because is it possible that the solicitor's just forgotten about that? Because, he deals with hundreds of cases, he or she deals with hundreds of cases. If you don't remind them that it's an £8,000 cap, they just might have forgotten.
I did say it in the email when in the beginning, once we received that, we did reply back to it saying that you did agree to this because you had an affiliation with our company
OK, so back to the question I asked you a moment ago. What did they reply when you said there was a cap on the fee? Because you said you didn't put it in those terms.
He just sent a report with all the work that they've done.
Fine, which is neither here nor there.
15 pages.
Yeah, neither here nor there.
No clear answer.
Yeah, so first of all, don't pay it. Second of all, I would don't do this over the phone, write to them and say, here is the email where you agreed to charge us a cap of £8,000. You're trying to charge us £26,000. We are not prepared to pay it. If you think there is a reason why you are legally entitled to this money, please tell us. And if they don't give you an explanation, you can laugh when they send you bills. If they try to sue you, a judge is probably going to refer them to the Solicitors Regulation Authority for professional misconduct. You can't promise to pay a client to cap a client at £8,000. Then send them a bill for 26. That's professional misconduct. And you certainly can't refuse to offer an explanation as to why they're charging 3 times as much.
Okay.
If it's as straightforward as you're telling me, Indy, and of course I haven't heard their version,
honestly,
you won't have any difficulties here at all.
Sure, it's exactly as I'm telling you.
Okay. And just one other question. The case didn't go out of scope, did it? Which means, for example, the 8,000 quote was for representing you in the county court, but what actually happened was there was a case in the county court and then an appeal in the High Court, which takes it out of scope of what was agreed.
Absolutely none of that happened. He gave a breakdown in that 8,000 cap email. He done an attachment, and I printed it. And then they say, stage 1, I'll be doing this work for you. Stage 2, I'll be doing this. And it's all the way from the beginning to right to the end of facing court as well in Hastings, where the court was, we were summoned to go to court.
Okay, Indy, you're going to be absolutely fine with that. As I said, just say, we fixed this. We've agreed 8,000. I'm not paying you a penny more unless you can explain to me why you think I'm legally responsible for it. And you won't hear back from them. They're just trying to eke some extra money out of you. It's reprehensible professional conduct. And Frank, I personally think that any lawyer who does that should be struck off. But then I don't have the power to strike lawyers off, or I'd be getting out my pen left, right and centre.